The petition for guardianship of a person with a developmental disability. Hi, I'm Darren Findling of the Probate Pro, and we're going to examine SCAO Form PC 658. SCAO, which stands for State Court Administrative Office, PC for Probate Court. This is a Probate Court Form 658. It's readily obtainable. We'd be happy to give it to you free of charge if you contact our office. This form is used in a very particular context, and it shouldn't be confused with a guardianship petition that is used within the probate proceeding. So remember, this is specifically for a person with an alleged developmental disability versus somebody that is in need of guardianship under the probate code. So this applies to the mental health code and the statutes that are reflected at the bottom right corner, MCL 700.330 at SEC, which means following those statutes, as well as the court rules that govern the appointment of a petition for an individual who has been diagnosed with a developmental disability and is in need of a guardian. So Michigan law differentiates between the mental health code and the probate code. So it's very important that you understand the difference between this petition and the adult petition for guardianship, which often gets confused. Again, we strongly urge you with any of these types of forms to be working with a skilled, competent probate practitioner who knows how to navigate through the probate court system, who understands the differences in these types of forms and how to use them, how to fill it out, and how to go through the court process to accomplish the goal. It's really frustrating when you fill out a form like this, file it with the court only to learn that you've done it wrong, filled out the wrong form. So let's work our way through it. Top left corner is the county in which you are filing the petition, and with every petition, you file a petition, you sign it, it gets scheduled for hearing. Notice is provided to the interested persons as defined under the statute and court rule, and then it gets scheduled for a hearing, and then an order would get entered. So it's a petition, and hopefully you get an order that's favorable. Top right corner is the case number. When you file the petition, you're not really filling anything in here because the court is going to assign the file number to the petition after you filed it and paid the requisite filing fee. Again, it's filed at the mental health division of the probate court, not at the probate court itself. The section A, we'll use those section numbers or section letters to help identify where we are in the matter of. This is simply the name of the individual who you are filing the request for the petition for guardianship, who has a developmental disability. The name of the person that's filing it is under B. So A is the person that is the subject of the petition. B is the person that's actually preparing the petition. And you can state your interest. And under Michigan statute, there's a defined class of people, it's pretty broad, who can actually file the petition. So are you the mother? Are you the child? What is your relationship to the individual upon which you're filing the petition? Section C identifies for purposes of jurisdiction and venue, whether there's already an existing family division of the circuit court proceeding that's already going on. So for example, if there's a divorce proceeding and the court already has jurisdiction of the family matter within it, you'd identify it there. Or if there's another pending petition that has been assigned to a judge or to a court, you'd reflect that in Section C. For Section D, you're giving some real basic information, the date of birth, the present address, where they're living at, are they living at a house or in a facility, and what's the address and the last 4 digits of the Social Security number. Also, if they're a citizen of a foreign country, you have to identify it there. I'm not going to go into it here, but it's a requirement that you identify in that particular part. The presumptive heirs, what does that mean? Well, under Section E, you're identifying the relationship, the people that are entitled to receive notice under Michigan's statute, the mental health code, and the presumptive heirs are reflected there. And they don't give you a lot of space here. So you may have to attach additional information to make sure that you identify all the people that are entitled to notice. And we're not going to go through the noticing part here in this presentation because it's a little confusing, it's a bit involved. But again, work with your attorney to make sure that you know who the right people are that are entitled to notice. Now, had there been an evaluation as required by law, you may be accompanying the petition, or if it doesn't accompany the petition, maybe it's going to be filed at a later date. And this is an important piece of this petition. One of the most challenging parts about getting your petition granted is this reporting and evaluation requirement that when you're filing a petition for an alleged developmentally disabled individual, you have to have really comprehensive reporting and evaluations of the various aspects of that individual for them to qualify as a person in need of a guardian. Section G is the description of the bases for the establishment of the DD, Developmental Disability Guardianship. So Section 1, it says it is attributable to a mental or physical impairment or a combination of mental and physical impairments. And then 2, it was manifested before the individual was 22 years old. So that's the defined age range upon when the manifestation of these impairments or behaviors are reflecting themselves. It had to have occurred before the individual was 22 years old. So again, if something is onset or discovered on the 23rd birthday, it's too late. If it was at the 20th birthday, it's sufficient. 3, it is likely to continue indefinitely. So the idea here, unlike a guardianship of an adult, which can be a short-term process, a guardianship of a developmentally disabled person is that this person has a lifelong disability that will remain indefinitely with them. They're not going to age out of it or grow out of it or recover in some way from it. So it's, again, a very particular nuanced understanding of how this statute works. And 4, it results in substantial functional limitations in a major life activity. And then again, is self-care, self-direction, receptive and expressive language, capacity for independent living, learning, economic self-sufficiency, and mobility. These are the statutes that you have to meet the definition. So again, working with your physician, psychologist, neurologist, psychiatrist, whoever it may be, you have to determine, do they meet all 3 of those requirements under Section G, and does it affect their, it results in a substantial functional limitation in their major life activities. Because we know with individuals there are various levels of functioning ability. And here it is, the term is substantial functional limitation. So that's the threshold that has to be achieved in those particular areas. So you use those little checkbox, you'll work with your treating evaluator or doctor or psychologist to help with that piece there, as well as your attorney. But here's another piece of it. It requires and it reflects the individual's need for a combination and sequence of special interdisciplinary or generic care, treatment, or other services that are lifelong or for an extended duration and are individually planned and coordinated. So again, this is not a short-term procedure or short-term process in place. This is an indefinite process relating to the disability for a developmental disabled individual. H gives room for the specific nature and the extent of the disability. So a description of the disability is a place for you to put it in there. And again, you can attach, of course, extensive information. You can add on to it on Section H to give a full description. Because again, not everyone fits into a neat bucket or neat diagnosis. So here you can give specific nature and extent of the disability. You can describe it in your terms or in the physician's terms or the treating professional's terms. On the back side of the form is Section I, which is what is a guardian going to do? How are they going to assist the individual in certain responsibilities and duties? So again, you can identify the full range of needs and you can limit the needs. So for example, if a guardian is needed for very specific purposes, you can limit the full extent of that guardianship, or it can be very broad. And that's Section I. for a description of how is the guardian going to be able to assist in the responsibilities and duties. Section J is a description of assets and income. Remember, income is money coming in, assets is already what's held. There may not be any, or there may be government benefits that are currently being received, Social Security and so on. So there's the spot for it. And the reason for that is in the DD, Developmental Disabled Guardianship, we differentiate quite differently from a Michigan guardianship and conservatorship. We call it a guardianship of the person and the guardianship of the estate. And you can be both, it may just be one. So if there are assets that need management, there may be a need for a guardianship of the estate. And if there's simply a need for assisting the individual with their responsibilities and duties, their day-to-day needs and care needs, that may just simply be a guardianship of the person. So here is the request part. This is very typical in a petition. You state the basis, and then you, as the petitioner, say, this is what I'm looking for. I am requesting that. And then number 10, if a report does not accompany the petition, the court orders an evaluation to occur. So if you haven't already done the evaluation and reporting, you're asking the court for that order. Number 11, the court determines that the individual requires a guardianship of an individual. So again, you wouldn't be filing this petition if number 11 wasn't true, because you're asking the court for the court to deem the individual that is alleged to have a developmental disability to be determined to be an individual with a developmental disability, and that under Section K, you're asking the court to appoint an individual to be the guardian, or appoint some other suitable person or entity. And again, here's this language we spoke about a little bit earlier. Plenary, which is another term for full, which is a broad-based guardianship. Individual, for their well-being and care. Estate, representing assets and financial matters. And it can be a partial guardian with certain powers or limitations of their power. So again, careful checking of those boxes depending on the unique circumstances relating to that individual. Now, if the proposed guardian is currently the service provider, you have to identify there that no other individual or agency is suitable to serve. And again, there's a lot that goes behind that, but they want to make certain that before the proposed guardian as a service provider is identified, that the court has ascertained whether there's any other individual agency that's suitable to serve. Now, L provides if there's a need for the guardian to execute an application for admission to a treating facility or hospital, that would be reflected under 13. And 14 is if while the petition is pending, before the full hearing, whether there is a need for any emergency powers to be exercised. Is there some emergency? These are typically life and death decisions that need to be made, and we need somebody to have powers to act within that time period. As we work further down, this is the section for the court to identify who they're appointing. If there's going to be a standby guardian, and often there is, you have a guardian and then you have a standby. Now this is unique because in Michigan's general guardianship under the statutes, under the probate code, for adult guardianships, not for those with a developmental disability, there is no such thing as a standby guardian. So it's a really nice aspect of Michigan's DD statutes. Again, with all these petitions, these SCAO petitions, there's a declaration under the penalty of perjury that the information contained within is true to the best of your information, knowledge, and belief, a spot for the petitioner to sign with their address and information, as well as a spot if there's an attorney involved. Again, there's so much going on here. And we know that when people are filing and preparing these petitions, it's often hard to get just through the first step of getting it filed with the court, because most of the courts will not even allow you to file this petition until all of the testing requirements have begun or are already in place. So this petition itself is quite confusing, and the process is just not all that intuitive or easy to navigate through. So again, working with a really skilled, competent probate lawyer is going to help navigate through this probate process. At the Probate Pro, we are passionate about everything probate. If you have questions about the petition relating to a developmental disabled individual or any probate or trust related issue, visit us at theprobatepro.com or call us at 1-833-PROBATE.